seek your lordship's indulgence.
Yes.
I have some personal difficulty today. So if my items 4, 5, and 6 may kindly be adjourned for next week. Four and 5, your worship, may be adjourned for next week, and 6 after 2 weeks.
6, you are there also.
6, I'm there. I'm assisting the senior counsel.
Okay, as paid for by Mr. A. Malhotra, learned counsel for the appellant, not objected to by the other side. Matters as stands adjourned for a week. 4, 5. Similar order in item 6, but this will be 2 weeks. Yes.
And if I may be allowed to mention item 2 also.
2 is for what?
2 is for admission today.
Admission hearing?
Yes. I have a personal problem today, Your Worship. This can come up after a week.
Okay, item 2 after a week. Similar order after a week. What about this item 7?
Item 7, Your Worship, my senior Mr. Ramzal is appearing.
I see. So, we are left with only about 3 matters. Yes.
I seek your lordship's indulgence in mentioning item number 8 of the hearing list, your lordship. I've taken the consent of the opposite party, and if this matter may be listed after 2 weeks, your lordship.
What is the difficulty?
Sorry, your lordship.
What is the difficulty?
Your lordship, I have sought further instructions for the documents, and the concerned respondent, that is the PWD, they have sent it to the secretary, but it has not yet received by me. So therefore, your lordship, I need those documents which are very essential to further my arguments. So
You have not filed your affidavit or what?
we have filed, your lordship, but then a rejoinder was filed, and therefore there was a need to reply to that rejoinder, your lordship.
How will you reply? You want to file another additional affidavit?
If it is required, your lordship, depending on the instruction that has been, the documents that are sought.
1 week, 2 weeks?
2 weeks, your lordship.
Ms. Louis, learned government advocate appearing for the state respondent, submits that she may be granted 2 weeks' time to obtain instructions on the rejoinder affidavit filed by the petitioners. Stop in view of above, matter stands adjourned for 2 weeks.
Much obliged, your lordship.
Orders, item number 3.
May it please the lordship. My lord, this is an application for impleading the state Mr. Vilal Chazwala as respondent number 9, since there's been a change of authorities in the post of my lord.
Whom do you want to implead?
Vilal Chazwala.
He's not Vilal Chazwala. Check.
Vilal Duzwala, my lord. My apologies. He's a director, Land Revenue and Settlement Department. Respondent number 9, yes, my lord.
Who's there for the other side? Any objection?
No, my lord.
Okay. Heard Mr. Lalro Kumapautu. Learned counsel for the applicant who submits that by filing this application, the applicant prays for impleadment of Shri Vilal Duzwala, who is the new incumbent holding the post of Director, Land Revenue and Settlement Department, as respondent number 9 to the connected contempt petition. He submits that his impleadment is necessary for effective compliance of the court's order. Stop. In view of above, Your good name, Miss.
H.C. Deborah.
In view of above, we cancel that. Miss H.C. Deborah, Learned Counsel,
For respondent 1 and 8.
appears for respondent numbers 1 and 8 and has no objection to the prayer. In view of above, Sri Bilal Duzwala is hereby impleaded as the respondent number 9. Please rewrite that again. We cancel in view of above. In view of above, Sri Bilal Duzwala, Director, Land Revenue and Settlement Department, is allowed to be impleaded as respondent number 9 in the connected contempt petition. Stop. Next para. IA stands disposed of as allowed. Stop. Next. In the main contempt, in view of the order passed today in IAC number 189 of 2024, Sri Bilal Duzwala, Director, Land Revenue and Settlement Department, Government of Mizoram, Aizawl, is hereby impleaded as respondent number 9. Stop. The petitioner shall submit amended cause title in 2 sets before the registry of this court within a period of 1 week. Next para. Issue notice to the newly impleaded respondent number 9, returnable by 3 weeks. Petitioner to take steps for service of notice by registered post with AD due within 1 week. List the matter again after 3 weeks.
Obliged.
For admission, item number 1.
Well, in this matter, I have filed my rejoinder affidavit stating the grant of compassionate allowances to various service personnel who were dismissed from on account of conviction under the POCSO Act.
Where is your additional agenda?
My lord, it's annexure. It starts from annexure 1, my lord. This is the show cause notice wherein the compulsory retirement was given to Mr. C. Lalin. He was convicted under Section 6 of POCSO Act, and his appeal is still pending, if I'm not mistaken. And
This is an instance of another case.
yes, another case.
Another case wherein a person was convicted, appeal is pending,
Yes,
and then some benefit has been released.
yes, he was given compulsory retirement, the benefit of compulsory retirement.
Besides compulsory retirement, what benefit did he get?
Retirement service at annexure 2, my lord.
Yes.
The lordship will see that in A, that pension, the class of pension is compulsory, and in B, retirement service gratuity and leave encashment as well. All the claims are similar to the present case, my lord. All the claims in the present case is similar to this particular person which has been granted.
What is the claim in the present case?
The claim is that he under order 40 of the CCS pension rules, compassionate allowance was claimed by the petitioner, and under the pension leave rules 1972, he has claimed for leave encashment as well, 300 days of leave encashment.
Where is the petitioner now?
He is in jail, my lord.
He's in jail.
Yes.
So how will he receive the money, even if it's allowed?
So that will have to be taken up by the government side, I guess, my assumption,
You have been appointed as a legal aid counsel.
my lord.
Why is that?
A court appointed, my lord. Court appointed. The court appoints me, my lord.
The court appointed, but why the The person has filed his appeal or petition from jail.
Yes, my lord. This is a petition from jail.
Compassionate allowance is under what provision?
Rule 41 of the CCS pension rules, my lord. In the book, it's in page 105.
Please read.
Compassionate allowance. A government servant who is dismissed or removed from service shall forfeit his pension and gratuity, provided that the authority competent to dismiss or remove him from service may, if the case is deserving of special consideration, sanction a compassionate allowances not exceeding 2/3 of pension or gratuity or both, which would have been admissible to him if he had retired on superannuation pension. The competent authority shall, either on its own or after taking into consideration the representation of the government servant, if any, examine whether any compassionate allowance is to be granted and take a decision in this regard, in accordance with the proviso to Sub-Rule 1, not later than 3 months after the date of issue of the order imposing the penalty of dismissal or removal from service. The competent authority shall consider a. each case of dismissal and removal from service on its merit to decide whether the case deserves of special consideration for sanction of a compassionate allowance, and if so, the quantum thereof, the actual misconduct which occasioned the penalty of dismissal or removal from service, and the kind of service rendered by the government servant. In exceptional cases, factors like family members dependent on the government servant along with other relevant factors. Where an order imposing the penalty of dismissal or removal from service was issued before the date of commencement of these rules, and the competent authority at that time did not examine or decide whether or not any compassionate allowance was to be granted in that case, that authority shall take a decision in this regard, not later than 6 months from the date of commencement of these rules. No compassionate allowance shall be sanctioned after the expiry of the aforesaid period of 6 months to a government servant on whom a penalty of dismissal or removal from service was imposed before the date of commencement of these rules. A compassionate allowance sanctioned under the proviso to Sub-Rule 1 shall not be less than the amount of minimum pension under Rule 44.
So do you qualify on this?
Yes, my lord.
How? Now there's a limitation also, 6 months.
My lord.
When was the petitioner removed or dismissed? What is the penalty given to the petitioner?
Life imprisonment, my lord. He was convicted for murder.
No, on his service.
Removal from termination of his service, my lord.
Where is that? Order of his termination from service. You don't have any documents with you?
I have, my lord.
You show me, where is the termination order?
The termination order has not been annexed, my lord. Only the suspension orders.
Okay, if order is not there, any statement to that effect, what is the date?
My lord, as per my humble knowledge is that he was suspended and reinstated, and subsequent to his conviction, he was terminated. His conviction was in 2012.
I'm asking about the termination, not conviction.
My lord. His termination has not been annexed, my lord.
You don't have the documents with you? Any documents with you?
The termination? No, I don't have, my lord.
Not only the termination, the writ petition filed by the petitioner from jail.
I have the petition, my lord.
If you have that, please turn to page 64, annexure Roman 4. That is the termination order.
My lord.
There is no pagination except pagination in red color. Have you found it?
Yes, my lord.
What is this? Is it not the termination order?
Yes, my lord.
Why
This
don't
is
you
the
point it
termination
out? You have not prepared the case or what?
order. I have prepared, my lord.
Then? Simply appearing as legal aid counsel will not do. You have to prepare. See, person was suspended,
Yes, my lord.
reinstated,
My lord.
then criminal proceedings initiated, trial ended in his conviction for life. And by this order of 19 February 2013, he has been terminated, dismissed from service with immediate effect. Now, according to his application, he says that he has submitted some representation.
Yes, my lord.
Where is that?
It's not in the petition, my lord, but the states have annexed the same the rejections in their affidavit in opposition.
This conviction is under what section?
302, my lord.
Murder.
Murder.
You come to this second page, or it's page 34 otherwise. I don't know how they've paginated it, but it's page 34. Have you got it? Basically the fourth page from the beginning.
Yes, my lord. Yes, my lord.
It starts with my lord.
Yes.
Please read that.
My lord, most humbly and respectfully, I beg to inform you that I have submitted an application to grant a compassionate allowances not exceeding 2/3 both of pension and gratuity to the Secretary, Government of Mizoram, Department of Personnel and Administrative Reform, Secretariat Service Wing. I resolve competent authority as admissible under Rule 41 of Central Civil Service Pension Rules 1972 several times.
Okay,
But-
stop there. Several times means when? When did he submit?
That is not on record, madam.
Huh?
That is not on record, madam.
So you find out
Madam.
person is in jail.
Madam.
You are the legal aid counsel. You should find out. You see, things that you've just read a provision here, which says that 6 months from the date of dismissal or termination. He was dismissed in 2013.
Yeah.
So, Where is 6 months now? So what is important is when did he submit his application? He says, I have submitted several times. There's no document. But he says that my applications were regretted. Then he's filed his writ petition. So if we had to go by the provision of Rule 41 of the CCS pension rules, we have to see whether these conditions have been fulfilled. Otherwise, we cannot just grant him this, isn't it?
Yes, my lord. Kindly allow me 2 weeks, my lord. Then
So unless we have these facts, how do we proceed? Is there any document in this bunch of papers wherein his application has been rejected?
in the state's affidavit, my lord.
Where is that? Show me.
Annexure 1 of the state affidavit. June 2013. And the reference date is 22, reference letter is 22/4/2013. The date of application.
So this was February, March, April, May, June. Exactly after 4 months of his dismissal from service, this rejection order has come.
My lord.
And please read this reference.
Reference your letter number nil, dated 22/04/2013.
So these are the facts you have to know. He has submitted his application on 22/4/2013. Rejected on 19/6/2013. You have to point this out to the court.
My lord.
Instead of showing me the law, you should show me the facts first. This is what happened. This person has served for this many years. He was suspended, convicted, dismissed, application submitted on so, rejected on so. However, as per the provisions of law, these are the things which he is entitled to. Like that. You cannot put the cart before the horse. We have to appreciate the facts first. Now, this has been rejected in 2013 already. Now, where is the scope of opening this again?
My lord, I have submitted citation in that regard. It's in 2014, 11 SCC 684.
What does it say?
My lord, it's a claim for the same compassionate allowances by a constable, and departmental action was initiated against the petitioner on 1995, and he moved a representation to the Joint Commissioner on 2005, and the same was rejected by the Joint Commissioner, and he approached the Deputy Commissioner on the same on 25th April 2005, Deputy Commissioner of Police, and the same was rejected again, and he had approached the Honorable Supreme Court after the High Court rejected the claim, and the Supreme Court has set 5 parameters which has to be considered in granting compassionate allowances, and that is in paragraph 14.
Before
14
that,
onwards.
what was the ground for rejection?
The ground for rejection is
Was it because of delay? Was his application on time or not?
it. Inquiry was furnished to the appellant on 1996, my lord. Inquiry report. And he was dismissed in 1996, my lord.
Which month, which date?
14, 22, 3, 1996. 22, 3, 1996. The inquiry report was given to the appellant, and he was dismissed on 17, 5, 1996.
17/5/96,
Yes,
dismissed.
yes, my lord.
Then when did you file the application? Or when was the application rejected? Whichever.
As per the representation, it was rejected on 22, 3, 2005, paragraph 8, my lord.
22,
3, 2005.
2005.
Yes, my lord.
So can you just count the years? Dismissal in 1996,
96.
rejection in 2005.
Roughly
Probably there was some delay,
9 years, my lord.
roughly 9 years.
Yes, my lord.
So was that the reason why it was rejected?
No, compassionate allowance was granted, my lord, to him. Compassionate allowances was granted to him, to the petitioner.
It was granted to him.
Yes, my lord.
That is a different thing. I'm asking you about the rejection by the High Court, rejection by the competent authority. Why was it rejected? Ultimately, it was granted because of the intervention of the Apex Court,
My lord.
isn't it? The question before I'm posing to you is, on what ground was this application rejected? Was it because of delay? Because you have read Rule 41, which says 6 months. No compassionate allowance shall be sanctioned after the expiry of aforesaid period of 6 months.
Paragraph 12, my lord, if lordship will see paragraph 12.
Yes, what is there in paragraph 12?
I'll read, my lord, if lordship permits. Agreed with the order of the tribunal dated 28 to 2006, the appellant filed writ petition number 14924 of 2006 before the High Court.
Just a minute, just a minute. Okay, now you read paragraph 12.
Aggrieved with the order of the tribunal dated 28/2/2006, the appellant filed writ petition number so-and-so of 2006 before the High Court. The High Court examined the submissions advanced on behalf of the appellant. It dismissed the claim of the appellant for compassionate allowance on the following considerations. Considering the aforesaid plea, we had directed the petitioner to file an additional affidavit to give particulars and details of the reasons which constrained him to avail leave without pay and to set out other special circumstances in support of his plea for compassionate allowance. The additional affidavit was not filed within 2 weeks as directed. However, further time was granted by us to the petitioner for filing the additional affidavit by order dated 11/10/2006. The additional affidavit that has been preferred by the petitioner, unfortunately, apart from mentioning in para 6 that the petitioner's condition was pathetic and his wife has suffered from cancer and that he was apprehending amputation of his leg below the knee, does not contain any averments with regard to the various bereavements suffered or the illness of his wife, or the treatment thereof, and the respective deaths which came into the way of the petitioner from taking legal remedies. He has not brought forward any extenuating and special circumstances which had continued since then, which had prevented him from taking timely remedies or would entitle him to compassionate allowance. The medical certificate of the petitioner no doubt shows that he is diabetic and under treatment. Therefore, however, it also shows that the petitioner has been a chronic alcoholic and drug addict. Considering the aforesaid factors, while one may sympathize with the petitioner's present condition, we are not satisfied that the petitioner has succeeded in making out a case for grant of compassionate allowance, and the discretion exercised by the authorities cannot be said to have been vitiated by any extraneous or irrelevant factors.
Just read the 5 conditions.
It starts from paragraph 14. In our considered view, the determination of a claim based under Rule 41 of the Pension Rules 1972 will necessarily have to be sieved through an evaluation based on a series of distinct considerations, some of which are illustratively being expressed hereunder. Was the act of the delinquent which resulted in the infliction of the punishment of dismissal or removal from service an act of moral turpitude? An act of moral turpitude is an act which has an inherent quality of baseness, vileness, or depravity with respect to a concerned person's duty towards another or to the society in general. In criminal law, the phrase is used generally to describe a conduct which is contrary to community standards of justice, honesty, and good morals. Any debauched, degenerate, or evil behavior would fall in this classification. Was the act of the delinquent which resulted in the infliction of the punishment of dismissal or removal from service an act of dishonesty towards his employer? Such an action of dishonesty would emerge from a behavior which is untrustworthy, deceitful, and insincere, resulting in prejudice to the interests of the employer. This could emerge from an unscrupulous, untrustworthy, and crooked behavior which aims at cheating the employer. Such an act may or may not be aimed at personal gains. It may be aimed at benefiting a third party to the prejudice of the employer. 3. Was the act of the delinquent which resulted in the infliction of the punishment of dismissal or removal from service an act designed for personal gains from the employer? This would involve acts of corruption, fraud, or person profiteering through impermissible means by misusing the responsibility bestowed in an employee by an employer, and would include acts of double dealing or racketeering or the like. Such an act may or may not be aimed at causing loss to the employer. The benefit of the delinquent could be at the peril and prejudice of a third party. 4. Was the act of the delinquent which resulted in the infliction of the punishment of dismissal or removal from service aimed at deliberately harming a third party interest? Situations hereunder would emerge out of acts of this service causing damage, loss, prejudice, or even anguish to third parties on account of misuse of the employee's authority to control, regulate, or administer activities of third parties. Actions of dealing with similar issues differently or in an iniquitous manner by adopting double standards or by foul play would fall in this category. Was the act 5. Was the act of the delinquent which resulted in the infliction of the punishment of dismissal or removal from service otherwise unacceptable for the conferment of the benefits flowing out of Rule 41 of the Pension Rules 1972. Illustratively, any action which is considered as depraved, perverted, wicked, treacherous, or the like, as would this entitle an employee for such compassionate consideration.
So you qualify under what provision out of these 5 conditions?
My lord, murder is an act of moral turpitude, no doubt. But the states had the law. It was only because the law had taken its course that he was convicted, my lord. Otherwise, they have forgiven each other, my lord, the deceased family and himself. It was duly signed. It was reflected in the judgment as well, my lord. But only since the law has taken its course, he was convicted. And
Is it compoundable, 302?
no, my lord.
Then? Anything mentioned in this judgment about delay?
No, my lord.
Because you read that Rule 41, 6 months.
The findings of the court is, the apex court is in paragraph 18, my lord, wherein it was directed that the competent authority should reconsider the claim of the appellant for grant of compassionate allowances.
This was a case of willful absence from duty, isn't it?
Yes, my lord. Around 320 days.
Willful absence from duty. He did not participate, willfully absented during the departmental proceedings also. Ultimately, he was dismissed. Supreme Court has drawn 5 parameters under which a person will not qualify for compassionate allowance. In your cases of a murder, you have been convicted under 302. And if you go to the provision, grant of this allowance is not automatic. Competent authority shall either on its own or after taking into consideration the representation of the government servant, if any, examine whether any compassionate allowance is to be granted and take a decision in this regard in accordance with the provisions of Sub-Rule 1. No, there's no question of delay. If you read the rules properly, Rule 4, this is regarding the commencement of these rules. When was this rules commenced? If there was any removal from service and the competent authority had not decided about the compassionate allowance, 6 months period was granted to complete this. And beyond that, it will not be extended. When an order imposing the penalty of dismissal or removal from service was issued before the date of commencement of these rules, and competent authority did not examine and decide about the compassionate allowance, authority shall decide in this regard not later than 6 months from the date of commencement of these rules. So this pension rules commenced from which date?
Pension rules.
20th of December 2021. At any rate, this is not an issue in your case because your prayer for compassionate allowance was submitted by you because you were aware about these provisions way back in 22/4/2013, and on 19 June 2013 it was rejected already. Now from jail you have preferred this writ petition for the second time. So I don't know what happened in the first round. There was some other legal aid counsel.
Yes, my lord.
Nothing happened. Second time he has filed. Then you have come. Now, on what grounds can you be granted this compassionate allowance? You have already read your own judgment, which you have cited today. If you come under any of those 5 conditions, you are not qualified to get compassionate allowance.
My lord.
You have been convicted under 302 for murder. Is there any appeal pending?
No, my lord. It has been rejected.
Appeal has been rejected.
Has been rejected. Dismissed.
Yes, government.
My lord, we have received his application thrice and it was considered thoroughly by the department. However, my lord, it was rejected thrice.
How was it considered thoroughly?
My lord,
Please demonstrate.
in the order it's not given. However,
Then?
the reason is that, my lord, he is guilty of committing murder and he has been sentenced to undergo rigorous imprisonment for life.
When was he convicted?
It's in 2012, my lord.
Are you sure?
It's 1912, 2012.
Okay.
This is the judgment.
And that was the reason why he was dismissed also.
Yes, my lord. And according to the rules, my lord, it's stated that in the case he is deserving of special consideration. But in his case, my lord, we have stated that he is not deserving of any special consideration because his wife is also a government servant. She's an assistant grade. And whatever medical expenses, he can reimburse through his wife. And the judgment which he has mentioned, not the judgment, the other person which he has mentioned, my lord, all these people, they are not convicted for life. Some are under PC Act and one is imprisonment for 20 years, whereas he has been given life imprisonment.
Where have you stated all that?
At para 10 of my affidavit, this is with regard to his statement in the petition. The nature of offense which was mentioned about the other MCS officer is misappropriation of government funds.
Sorry?
Para 10.
Yes. Read.
That with regard to the statements made in paragraph 11 of the petition, I say that the petitioner's claim of his dismissal due to accidental criminal case is found to be inaccurate, since the judgment and order dated 19/12/2012 has concluded that the petitioner has intentionally caused the death of the victim. As such, the nature of offense committed by the petitioner, which is murder, and that of the mentioned MCS officer, which is misappropriation of government funds, are vastly different. Therefore, the offenses of the petitioner and the aforementioned MCS officer could not be treated in the same
Okay.
capacity.
Just pause there for a moment. Where is paragraph 11 in the writ petition? There's no paragraph numbers in his petition. So how do you reply to paragraph 11?
My lord,
You have a writ petition with you?
Page 40.
yes, my lord.
Page 40.
Page 40.
Page 40, madam.
But this does not solve the problem. You only have cited one judgment of the apex court, wherein there are 5 parameters are there.
Madam.
Now, wherein it says that the punishment imposed is because of an act of design for personal gains, which includes double dealing, racketeering, and also act of dishonesty, untrustworthy, deceitful, cheating. If these conditions are found, if these are found in your activities, you are not entitled for compassionate allowance. So this person who was an MCS officer was wrongly given compassionate allowance, isn't it? The judgment which you have referred to,
Madam.
5 parameters. He was punished because of, he was, what do they say?
Corruption.
Because of corruption, misappropriation of government funds. He should not have been given compassionate allowance. Was wrongly given. If he was wrongly given, you cannot also be wrongly given. That's the thing.
If I may, my lord, in paragraph 15 of the citation, in the judgment which I have submitted,
Yes.
the apex court has stated that the rule postulates a window for hope if the case is deserving of special consideration, my lord. That special consideration has not been duly considered, my lord.
What special consideration?
My lord. He has rendered 37 years of unblemished services, and he was a meritorious person, my lord. He was recommended for, he was given a certificate of merit by the concerned authorities several times, my lord. It has been annexed, and letter of appreciation has been given.
But
If any
court has
person-
found you of having intentionally caused the death of the victim, which, according to the respondents, may not be a deserving case for grant of compassionate allowance. What is wrong in that?
But my lord, my humble submission is that if any person is deserving of such benefits, none would be entitled than the petitioner, my lord.
Yes, Miss Linda, you continue. What else you want to point out? Your applications have been regretted 3 times already.
Yes, my lord. The applications are rejected, even though the grounds are not mentioned here, my lord. We have stated that the department has thoroughly examined this case. And he has been guilty of committing murder. And my lord, the court has sentenced him to rigorous imprisonment for life. So he's not a deserving candidate for this compassionate allowances, my lord.
But what about his plea that he needs an open heart surgery?
My lord, with regard to that, we have stated that his wife is also a government servant.
Where is that?
My lord, in para 7 of my affidavit. Para 7, the last paragraph, my lord. Accordingly, competent authorities under DPNAR had regretted the said application 3 times, as his case is found not deserving of special consideration, considering the gravity of the offense. With regard to his claim that he needs financial support for proper treatment and medication, it may be stated that his medical expenses are reimbursed by his wife, Pilusizai Tuami, Assistant Grade, DCSO, Aizawl West, from the government of Mizoram. So for financial expenses, my lord, his wife can reimburse. So that is why we have stated that he is not deserving any special consideration.
We'll keep the matter pending. Mr. Roku, are you prepared
My lord, my lord.
properly again? I don't want to close this matter straight away. Just see, do some more homework. You can
Definitely.
find something.
Yes, my lord.
Parties are represented by the respective councils, and they submit that the pleadings are complete, and the matter may be taken up for admission hearing. In view of above, list the matter for admission after
2 weeks.
2 weeks.
I'm obliged.
For hearing, item number 7.
Yes, Mr. Ramzao. You're for the appellant.
And for the appellant.
Ms. Linda is there for the respondent. Respondents are government.
Yes, Your Lordship.
Okay.
Initially, may I take Lordship to the facts of the case in connection with the
Mahak, you may go.
civil suit number 2 of 2018. Civil suit number 2 of 2018. Suit was filed on 7/3/2018.
Where is that?
Lordship will see from first page, page 1 of the paper book. This is a suit against the state of Mizoram and others, in which all the occupants of the lands of the plaintiffs were impleaded. The Secretary Government of Mizoram General Administration Department, Secretary Government of Mizoram Home Department, Secretary Government of Mizoram Public Health Engineering Department, Director, Land Revenue Settlement, Deputy Commissioner, Scholarship, this is the assessing authorities, a Block Development Officer, Officer in charge, Pilkotlir Police Outpost, and Junior Engineer, PHC Department, Government of Mizoram. And this is for declaration of right and title of the plaintiffs of the suit land, and for a decree declaring that the plaintiffs are entitled to payment of rental compensation as assessed by the defendant number 2, white letter so-and-so, from the defendants number 3, 4, 5, 8, 9, and 10, along with other consequential reliefs.
Who has assessed? Defendant number 2?
Defendant number 2 had made assessment, Your Lordship.
That is secretary.
Defendant number 2
His secretary.
had
Revenue.
directed, it is the Revenue Secretary, had made direction, and it is at the instance of the Secretary that the assessment was made
By whom?
by the District Collector,
But you say that.
Deputy Commissioner.
But you say that assessed by defendant number 2.
Compensation as assessed by the defendant number 2, white letter memo number so and so. Yes, 1415. Lordship, let me take a Lordship to page 59.
Yes.
59 is a letter addressed to, dated 1/4/2015. A letter addressed to the GAD, wherein it is stated, in continuation of a letter dated 3/3/2015 on the subject mentioned above, I am directed to send herewith assessment of rental charges to be paid by your department on account of occupation of private land at Bilkotlir. In a letter dated so and so, assessment sheet was not enclosed while only verification report sheet was sent earlier. Assessment sheet duly prepared by the joint verification team constituted as per Gauhati High Court judgment and order in connection with WPC number 31 of 2011 is hereby enclosed for payment. In Lordship, the lands of the plaintiffs were earlier occupied by the paramilitary forces. And they were also part of the verification team, and as directed by the Honorable High Court in connection with that earlier case in WPC number 31 of 2011. If I take a lordship to the judgment of the order of the Honorable Court, at page 35 to 45, lordship will see that 16 landowners who were the petitioners there in connection with civil WPC number 31 of 2011 had filed a writ petition impleading therein the Union of India, represented by Secretary, Government of India, Minister of Home Affairs, Director, Government of India, Minister of Home Affairs, and all the occupying departments, that is Director General, some rifles. Those are the central government entities. And from respondent number 5 to 14 are the authorities of the state government. And here, lordship, there was direction may I take lordship to page 42 at the bottom of the page. May I read the lordship?
Yes.
In view of the above submissions made by the learned counsel appearing for the parties, this case may be disposed of in terms of directions made in the said common judgment and order dated 9 June 2011, passed in WPC number 14 of 2010 and 5 others, which runs as follows. Quote, since a consensus has been arrived at in between the parties to the proceedings for constitution of a joint verification committee for the verification of the lands of the petitioners.
Mr. Ramzawa,
Lordship.
I have read it. Now, this is occupied by security forces,
Yes.
but the letter which you have just shown me at page 59 is occupied by GAD.
Yes. Thereafter, on the vacation of those lands by the central government agencies,
It was occupied by GAD.
yes, it was taken up by GAD, and some are taken up by the other departments, PHE and other departments, which have been impleaded here, Lordship. If I take Lordship to
So
page
this
49,
59 says under Secretary Revenue has forwarded the assessment sheet
yes,
for payment by the GAD.
GAD.
This was not paid, and that is why you filed the civil suit.
This is, yes, not only GAD, Lordship, some other departments like police department and the PhD department. GAD, because most of the occupants, those are AO, the lands were occupied for the purpose of AO's office and BDO's office. As can be seen
Okay, initially,
from page 53, Lordship.
initially it was occupied by the armed forces.
Yes, Lordship.
After they vacated, it was occupied by the civil authorities.
Yes.
So you're claiming rental compensation now from the civilian authorities
Yes, yes.
by filing this civil suit. But another thing which you have also claimed is for declaration of right and title. So on what basis are you claiming right and title?
Right and title, Your Lordship, we were issued the necessary passes,
What kind of pass was that?
VC passes, Your Lordship.
VC.
Yes. VC passes were issued to us.
So what happened to the civil suit?
The civil suit was not contested by the defendants. It was not contested and it was decreed ex parte.
Where is that?
Ex parte decree is at page 79. No. At page starting from 92, Your Lordship. Civil suit number 2 of 2018.
92.
Yes, page 92. Judgment and order, facts of the case, the issues, evidence, and findings. And there's an order and decree at page 101.
Decided ex parte.
Yes, Your Lordship.
Did you not contest?
They did not contest, probably because they knew that it was a case which was which will not bear any fruits, even if it was.
Where is the finding that they failed to contest?
At page 96. Lordship, reading from page 95 at the bottom, that the plain copy was duly served to the defendants on 7/3/2018. Last para of
Yes.
page 95. Which was reflected in the order, and the case record also clearly shows that the learned AGA had sent for instruction on 11/4/2018 to defendants. In spite of sufficient opportunity given, defendants failed to contest the suit by filing written statement to rebut or disprove the claim of the plaintiffs. Hence, as prayed by the learned counsel for the plaintiffs, the instant suit is proceeded without written statement in accordance with Order 8, Rule 10, as per the order dated 25/9/2018. Hence, the case is heard ex parte.
25/9/18. What is this?
It appears that prior to this, on 25/9/2018, there was an order for ex parte proceeding.
There is no date of judgment also. Date of hearing also is blank.
Date of hearing, date of order, yes.
The last part of the judgment says, given under my hand and seal of this court on 30th January
Yes,
2019. So this is the date.
this could be lapse on the part of the presiding judge. Your Lordship, the fact that it was proceeded ex parte,
So order and decree, page 101. It is hereby ordered and
is that
decreed.
on the basis of foresaid findings in various issues, it is hereby ordered and decreed that the plaintiffs are entitled to rental compensation as assessed by defendant number 2, white letter memo number so and so, with interest at the rate of 6% per annum from date of filing this suit till final payment. Defendant number 3, 4, 5, 8, 9, and 10 are directed to pay the plaintiffs rental compensation as assessed by defendant number 2, white letter memo number so and so, dated 1/4/2015, with interest at the rate of 6% per annum from date of filing the suit till final payment, and they are also liable to pay further rental compensation for the period beyond 2012 till the suit lands are vacated or acquired. After payment of rental compensation with interest, defendants are also directed to acquire the plaintiff's lands for future occupation with due process of law, if necessary. In the above terms, the case shall stand disposed of, no cost. So, Your Lordship,
So this is the decree in your favor,
this
judgment.
was the decree.
Then what happened after that?
After that, review petition was filed on
Review.
review. Yes.
Okay, where is that review?
At page 103.
103.
It's an application under Section 114 and Order 47, Rule 1, read with Section 151 of CPC, seeking review of judgment order dated 30/1/2019, passed by the senior civil judge in civil suit number so and so. The grounds taken by the review petitioners are under para 6, subclause 1, 2, 3, 4, and 5. Should I take a lordship to page 106?
Yes, I'm on
These are
it.
the grounds.
No chance was given
Yes.
and all that, according to them.
Stating that they were not informed without knowledge of the concerned state defendants, but no opportunity to contest the suit. Copies of the petition for all the state defendants was forwarded to the Deputy Commissioner Kolosip, Mizoram by Assistant Government Advocate Kolosip on 11/4/2018. And the said petition was never forwarded to the concerned state defendants. Assistant Government Advocate Kolosip, instead of forwarding copies of the plain to all the concerned state respondents, had erroneously sent copies of all the state respondents to the Deputy Commissioner Kolosip. That being unaware of civil suit number 2 of 2008, the petitioner had no opportunity to contest the suit. This is the first ground, and
Second ground has no meaning.
right.
Can that be a ground for review? There's nothing.
And third ground is that there was concealment of material facts by the respondent petitioners while filing the instant civil suit number 2 of 2018.
What is that material?
Village
fact?
Council passes of suit lands were cancelled in the year 1983 by the Village Council Bill Khotlir. Clarification with regard to the cancellation of such Village Council passes was made by the Village Council white letter dated 9/11/2015. The land occupied by PHC department was inside departmental land list number 51 of 1994. Therefore, payment of rental compensation does not arise. Also, the police outpost at Bill Khotlir is occupied under departmental land list number 51 of 1994. And 4. Land occupied by BDO Bill Khotlir is occupied under departmental land list number 2 of 2005, issued by Land Revenue Settlement Department, Aizol, Mizoram Secretary Rural Department, should have been impleaded as a necessary party to the suit. Also, Village Council Bill Khotlir, who had issued passes to the respondent and who accordingly cancelled such passes, should have been made a party to the suit. Due to non-inclusion of necessary parties to the suit, this honorable court may be pleased to review and set aside the judgment and order. Those are the grounds. And
Secretary, Rural Development Department should have been made a party, and also Village Council Bill Khotlir. This is another ground.
yes,
So basically, I think there are three grounds. Parties, non-joinder of necessary parties. The other one is concealment of the cancellation of the village council pass. And the other one is adequate opportunity to contest the suit. Because the government advocate or the assistant government advocate send the copies of the petition to the deputy commissioner,
yes.
Kolosip, and not to the government.
And the matter was adjudicated upon at page 122 by the Planet Senior Civil Judge on 28/10/2020.
122.
122.
Review was allowed or dismissed?
Allowed.
It was allowed.
Yes.
So it's against this order that you've come.
Yes, yes, Your
Okay.
Lordship.
Now, what has happened to the suit? The order has been stayed?
Because of the
Appeal.
order that was passed in review, which have been put to challenge in a instant proceeding, Lordship, nothing has been done. Final statement
There's a stay order.
in the review, yes.
Till the next returnable date, proceeding in civil suit will remain stayed. But then nobody bothered to inform the court about continuation of the stay. The first day of motion, stay was granted. Thereafter, it was not extended. Now, the LCR is here. Civil suit is there, isn't it?
Yes.
So if the LCR
And,
of the, it's in original or Xerox?
Lordship.
Sheet. The handwriting is so bad, can't make out what is written. When was the review allowed? Date?
Review was allowed on 28/10/2020.
28/10/2020. Okay. (28/10/2020). 28/10/2020.
Yes.
And the ex parte judgment is dated?
Ex parte judgment. January 30, 2019 at 1:02.
31/2019. This seems to be the order sheet of the civil suit. So that particular judgment of 31/2019 is not available. What is available here is framing of issues. What? This is review petition. This application. So the issues were framed on 1/11/2018. As many as 8 issues. Then fix 2011-18 for plaintiff evidence. Then plaintiff evidence came.
And
Okay.
plaintiff had produced one witness,
Yes.
Sri
Then
Lalbiak Sanga, son of
okay.
Rahul.
Correct. What is the initial? B. Bilal Biaksanga.
Yes, B. Lalbiak Sanga.
Okay. That was produced on he was examined on 2011-2018. Thereafter, the next order is fixed 31-2019 for judgment order. Okay, so judgment was passed. Now, after review was applied, was allowed, then on 6/11/2020. Yes. Review was allowed on 28/10/2020. So next court date was 6/11. Case record put up on account of order dated 28/10 so and so. Is restored to file. Then steps, then Learned Counsel Board review CMA. Okay, it's combination of delay. So what is wrong in the order of review?
Lordship, we have met the grounds of appeal in a present application.
We'll do one thing, Mr. Ramzawa. We'll take 5 minutes break and come back.
Right.
Now, more or less, the sequence is clear now. Writ petition was filed. Court directed certain committee or verification team to be formed and to pay compensation and make assessment. According to you, security forces have left, but the civil authorities have continued to occupy, and for which an assessment was made.
So far as the civil, the Central Paramilitary Force are concerned, they have met their payment.
Okay. So GAD was supposed to give you some rental compensation. Having failed to do so, you file civil suit saying that you declare my right and title. We have VC pass. At the same time, they should pay rental compensation. Opposite party failed to contest. Judgment was passed. Ex parte judgment was passed, decreeing the suit in your favor. Now they have filed review. Basically, three main grounds, and the court allowed review. And the matter was sent back to the civil court, civils for to consider the civil suit. And in the meantime, they had also filed one application for impleadment of the Rural Development Department, I think. What has happened, that is not discernible. Meantime, you have already filed this regular first appeal. That is where we are now. Now you have to satisfy the court why this review petition, review order passing the review petition should be set aside. That much.
Yes.
5 minutes. Yes, Mr. Ramza.
Lordship, I take Lordship to the Memorandum of Appeal,
Page,
page 130, 129. The grounds of appeal at 133.
yes.
May I take Lordship to ground number 2. For that, the learned lower court had failed to consider the fact that respondent number 1, defendant number 2, respondent number 1 is the defendant number 2, had filed the review petition, that is review petition number 2 of 2019, without impleading the pro forma respondents number 2 to 10. In fact, respondent number 1 who had filed the review petition was the defendant number 2 in civil suit number 2 of 2018, while the pro forma respondents number 2 to 10 were defendants number 1, 3, 4, 5, 6, 7, 8, 9, and 10 in civil suit number 2 of 2018. Hence, the respondent number 1, defendant number 2, could not have filed the review petition without impleading the pro forma respondents number 2 to 10, and as such, the impugned order dated 28/10/2020 is liable to be set aside in court. That is one technical ground.
Review was filed by State of Mizoram, represented by Secretary, Revenue. And what you're saying is that in the civil suit, there were as many as,
Yes.
how many respondents? 1, 2, 3, 4, 5, 6, 7, 8, 9. There were 10 defendants.
Yes, 10 defendants.
Out of 10, only one of them has filed
Only
the,
one have filed.
that is the defendant number 2.
Yes.
Okay, that is one technical ground.
Yes.
Then,
The third ground, for that plain reading of review petition filed by respondent number 1, that is defendant number 2, shows that the respondent number 1 had not impleaded the pro forma respondents, defendants, in the civil suit. This means that the pro forma respondents number 1, 3, 4, no, respondents number 2 to 10, that is defendants number 1, 3, 4, 5, 6, 7, 8, 9, and 10, were not aggrieved by the judgment and order dated 30/1/2019, passed in civil suit number 2 of 2018. As the respondent number 1, defendant number 2, and pro forma respondents number 2 to 10, defendant numbers and so are all representing various departments and officers under government of Mizoram. It cannot be held that only one department can be aggrieved by the judgment and order dated 30/1/2019, while the other departments are and officers under government of Mizoram are not aggrieved by it. And as such, the impugned order is liable to be set aside and quashed. So if they are aggrieved, they should also have approached the review court by filing or by making themselves parties in the review application.
you're reading ground,
Ground 3.
okay,
May I take a lordship to ground 4?
yes.
Reading of the impugned judgment and order passed in civil suit number 2 of 2018 shows that no order decree was passed against the respondent number 1 or defendant number 2. Therefore, there can be no reason or cause of action for the respondent number 1 or defendant number 2 to file the aforesaid review petition against the judgment and order dated 31/2019. And as such, the impugned order dated 28/10/2020 is liable to be set aside and quashed. 5. A plain reading of the impugned order dated 28/10/2020 shows that the learned lower court had allowed the review petition on the main ground that, as the latter dated 11/4/2018, that is Annexure 2 of the review petition, was addressed only to the district collector, who is the respondent number 7 or defendant number 7, and not to the respondent number 1 or defendant number 2, review petitioner. The copy of the plaint was not sent to the respondent number 1 or defendant number 2, review petitioner, by the government advocate. In this regard, the learned lower court had failed to rightly consider the ground taken by respondent number 1, defendant number 2 in the review petition, that the copies of the petition for all the state defendants was forwarded to the Deputy Commissioner, Colossi, by Assistant Government Advocate, Colossi, on 11/4/2018, and the said petition was never forwarded to the concerned state defendants. In fact, it cannot be concluded that just because a letter dated 11/4/2018 was addressed only to District Collector, Deputy Commissioner Colossi, Assistant Government Advocate had not sent copies of the plain to the respondent number 1 or defendant number 2 and the other defendants in the civil suit number 2 of 2018. And as such, the impugned order dated 28/10/2020 is liable to be set aside and quashed. So the presumption was drawn, Your Lordship, only on the basis of this letter dated 11/4/2018, stating that, or taking the ground that on the basis of this letter, it is clear that no other letter has been sent and the copy of the plaint was never given or furnished to the defendants at any point of time. That was the conclusion, the presumption made by the review petitioner, and which was also accepted by the review courts. And ground number 6, for that the learned lower court had wrongly concluded that the appellants or plaintiffs had failed to produce any evidence to show that a copy of the plaint or notice was sent to the respondent number 1, defendant number 2, but filed the review petition. In this regard, it submitted that the onus of proof was on the respondent number 1, defendant number 2, to prove that it had not received a copy of the plaint in civil suit number 2 of 2018 as claimed by it. The learned lower court could not have shifted the onus of proof to the appellants of plaintiffs. And as such, the impugned order dated 28/10/2020 is liable to be set aside and quashed. So it is the duty of the defendants or the pro forma defendants, and in fact, the review applicant, the review petitioner, that is defendant number 1, respondent number 1, defendant number 2, who had filed the review petition, to prove that no copy was served upon it and upon the other defendants. And ground number 7, for that learned lower court had failed to appreciate the fact that in the judgment and order passed in civil suit number 2 of 2018, the learned lower court had come to a definite finding that a copy of the plaint was duly served to the defendants on 7/3/2018, which was reflected in the order, and the case record also clearly showed that the learned AGA had sent for instruction on 11/4/2018 to the defendants. In this regard, the law is well settled that statements of facts as to what transpired at the hearing recorded in judgment of the court are conclusive of the facts so stated, and no one can contradict such statement by affidavit or other evidence. Hence, once the learned lower court in its judgment and order dated 30/1/2019 had come to a definite finding that a copy of the plaint was served to all defendants, respondent number 1 or defendant number 2 in its review petition could not have claimed that it had not received a copy of the plaint, nor could the learned lower court in the order dated 28/10/2020 come to finding that the copy of the plaint was not served upon the respondent number 1, defendant number 2. And as such, the impugned order is liable to be set aside and quashed. These are the technical grounds taken. Apart from this, Your Lordship, may I make a submission to the fact that under 47(1), the review ground is very much restricted. Order 47, Rule 1. CPC.
Do you have a foot rule? Use a foot rule to open this page. Yes, please proceed, Mr. Ramdao.
Yes, Your Lordship. May I read, Your Lordship?
Yes.
Application for review of judgment. Order 47, Rule 1. Any person considering himself aggrieved, A, by a decree or order from which an appeal is allowed, but from which no appeal has been preferred. B, by a decree or order from which no appeal is allowed, or C, by a decision on a reference from a court of small causes. And who, from discovery of new and important matter or evidence, which after exercise of due diligence was not within his knowledge, or could not be produced by him at the time when a decree was passed or order made, or on account of some mistake or error apparent on the face of the record, or for any other sufficient reason, desires to obtain a review of the decree passed or order made against him, may apply for a review of judgment of the court which passed a decree or made the order. Your Lordship, this ABC under Rule 1, by a decree or order from which appeal is allowed but from which no appeal has been preferred, by a decree or order from which no appeal is allowed, by a decision, and who, from the discovery of new and important matter or evidence. The question of having discovered new and important matter or evidence did not arise in the instant case, and no such thing has been stated also. And after the exercise of due diligence was not within his knowledge or could not be produced by him at a time when the decree was passed or order made, or on account of some mistake or error apparent on the face of the record, or for any other sufficient reason. In the review order, which is impugned herein, Your Lordship, the learned review court had stated that we will take, Your Lordship, to page 126.
Yes, 126.
Wherein it is stated, review of judgment is the substantive power of review by the court mentioned in section 114 of CPC. This section doesn't provide any limitation and conditions for review. Limitations and conditions are provided under Order 47 of the Civil Procedure Code. Order 47 contains 9 rules which imposes some condition for the review, and the grounds for review as clarified from the above provision, and some rulings may be indicated as under. 1. When new and important evidence is discovered by the applicant and he was not in knowledge or despite due diligence was not able to provide the evidence when decree was passed. 2. Power of review is available only when there is an error apparent on the face of the record and not on erroneous decision. An error apparent on the face of the record cannot be defined precisely, and it has to be decided judicially on the facts of each case. Any other sufficient reason, the word any other sufficient reason means a reason sufficient on the ground, at least analogous to those specified in the rule in so-and-so, reported in 2006 SCC. In analyzing the above submissions of the parties from the touchstone of the relevant provisions of law, it may be observed as follows. These are the reasonings. Should I read, Your Lordship?
Yes, you can read.
With regard to the first point, forth by review petitioner, it is observed that the assertion of the review applicant that the plaint in civil suit number 2 of 2000 was not received by this instant review applicant had not been countered or convincingly by the respondent hereof. To elaborate, it may be appreciated that even though it is acceptable that the submission of the respondent the plain reading of that letter dated so and so shows that Pu Joseph L. Pacho, learned AGA, had forwarded only one copy of the said plain to district collector Colosip and not all the copies of the said plain for all state defendants as claimed by the review petitioner hereof. The fact remains that as the said letter hereof is addressed only to district collector, who is the defendant number 7 in the said suit and not the instant review petitioner, a copy of the plaint is therefore not yet forwarded or sent to the instant review petitioner. And the respondents have also not made any effort to produce any evidence to show that copy of the plaint or notice was sent to the instant review petitioner or defendant. Hence, in these given circumstances, in the absence of any evidence to the contrary, there is no choice but to hold that the instant review petitioner was indeed not served a copy of the plaint in civil suit number 2 of 2018, and thereby did not have a knowledge about the filing or existence of the said suit before this court up until the impugned judgment and order dated 31/19 and the said suit was passed and received. In other words, it's clear that the instant review petitioner did not have any opportunity to contest the said suit as alleged, which was for all practical purposes decided and disposed without notice to the instant review petitioner. This means that whatever sufficient opportunity ostensibly indicated as being afforded to the review petitioner cannot be held to be to operate against the said review petitioner, since the said review petitioner did not have an effective notice of the said suit from the very first instance, till passing of the impugned judgment and order hereof. At this juncture, it may be argued that the receipt of a copy of the plaint by learned AGA, who represents the defendant, amounts to adequate notice upon defendants, even if the said AGA did not forward the same to the concerned department. This argument, though seemingly acceptable in theory, still cannot be deemed to extinguish the all-important element of justice in ensuring that no party is unjustly condemned without affording effective opportunity of being heard. In other words, when a party is proved to have no effective notice of the case filed against him, it would be quite unjust and unfair if the decision made against him behind his back is sustained on any ground without affording him a just opportunity to present his case. Now, considering the above findings, in the backdrop of the relevant provision of law hereof, there is no denying that the doctrine of odi alteram partem plays a pivotal role in the administration of justice, and the non-observance of it is not only apparently unjust, but manifestly unjust and unfair, even from the face of it, and is therefore analogous to those are the two grounds specified in the rule. Therefore, it is opined by this court that in the instant case, the third ground of review, any other sufficient reason, has been satisfactorily made out for the court to invoke its power of review. 2. With regard to the other reason put forth by the review petitioner and the counter-arguments made thereto by the respondents, as the same pertains to merit of the matter to be actually adjudicated, they are thereby considered as not irrelevant points of argument for the purpose of this present application, and are therefore not indulged upon by this court in the present instance. In the outcome, as already highlighted in the first observation, it is the considered opinion of this court to hold that sufficient reason has been made out for a review of the judgment of order dated 31/19, passed by this court in civil suit number 2 of 2018, thereby warranting grant of the prayer of the applicant hereof. Accordingly, and in order to ensure that effective justice is secured hereof, the following orders are hereby passed. Prayer of the applicant hereby stands granted. Judgment and order passed by this court in civil suit number 2 of 2018 hereby stands vacated. Civil suit number 2 of 2018 is hereby restored to file for adjudication as per law from states left. CR concern be accordingly put up forthwith for passing necessary order. So this was the view and the finding recorded in the said impugned order. Lordship, the land executing court had taken a refuse under any other sufficient reason, saying that the non-furnishing of a copy or copies to the defendants, or at least to the defendant number 1 and 2, is sufficient, is analogous to any other sufficient reason. This is what he has said in his order. But the thing is that, Your Lordship, before coming to such a conclusion, it is the duty of the learned executing courts that the defendants did not receive, all the defendants did not receive their copies of the notice or the copy of the plaint, which was served and which was said to be duly served upon them by the learned trial court in its judgment. When that statement was being made by the court itself, a reversal in the form of this observation will tantamount to deciding the case as if it were an appeal. But review court is not supposed to act as an appellate court. And also, regarding the technical grounds which have been raised, if the parties, the other parties such as defendants which have been arraigned now as pro forma respondents, such as State of Mizoram represented by the Chief Secretary, GAD, Secretary, Home, Secretary, PHC, Director of Land Revenue and Settlement Department, Deputy Commissioner, BDO, Bill Kotlir, Officer in Charge, Bill Kotlir Police Outpost, and Junior Engineer, PHC Department, Government of Mizoram. All these have been arraigned as pro forma respondents because they were not met parties, they were not filing, they were not aggrieved, and hence they did not approach the appellate court or the review court. It is only the
Secretary Revenue.
Secretary to the Government of Mizoram, Revenue and Settlement, Land Revenue and Settlement Department, that had approached this honorable court, the review courts. It cannot have a sweeping finding. The Revenue Secretary cannot have a sweeping finding that since I have not received even all the other respondents, that is, the pro forma respondents 1, 3, 4, 5, 6, 7, 8, 9, and 10 also did not receive. And that was believed by the learned review court without any proof whatsoever. Only from the submissions made without making any attempt to find out whether they had received it or not, and without asking them whether they had received such copies. The order that was made was more of a presumption, a sweeping presumption, Your Lordship, which cannot be accepted by this appellate authority. And it has never been said that the other departments who were also in occupation of the lands of the plaintiffs, one of the appellants, are also aggrieved other than the Revenue Secretary. In fact, no order was passed against the Revenue Secretary. They're not occupying it. It is only all those other departments who are in occupation of the lands of the plaintiffs, against whom the order was made for payment of compensation. They should have have filed whatever review or appeal if they are aggrieved. The fact is that in the course of spot verification, they all had participated. They all had participated in the spot verification, joint spot verification, which was conducted as directed by the Honorable High Court in the earlier case. So the question of believing or just because defendant number 2 had made such a sweeping remark that we have not received, so other also have not received. We are, though no order, no pinching order has been passed against us, but we may have to file this review petition. So how could the review courts simply accept those submissions made without any proof? This is the very important issue that needs to be decided by this honorable court. In fact, the first, the review court had acted as if it were an appellate court, reversing the finding which was already recorded by the learned trial court by coming to the conclusion that the defendants have not received the notice. And Your Lordship, in support of my contentions, if I take Lordship to the judgment, (2017) for SEC,
Page,
page 692.
paragraph.
From 5 to 9. Paragraph 5 is, in fact, it is Order 47, Rule 1 of CPC, which is quoted. Paragraph 6, Your Lordship. The grounds, may I read, Your Lordship?
Yes, yes.
The grounds enumerated therein are specific. The principles for interference in exercise of review jurisdiction are well settled. The court passing the order is entitled to review the order if any of the grounds specified in the aforesaid provisions are satisfied. Paragraph 7. In Tungabhadra Industries Limited versus State of AP, the court, while dealing with the scope of review, had opined, quote, what, however, we are now concerned with is whether the statement in the order of September 1959 that the case did not involve any substantial question of law is an error apparent on the face of the record. The fact that on the earlier occasion the court held on an identical state of facts that a substantial question of law arose would not per se be conclusive, for the earlier order itself might be erroneous. Similarly, even if the statement was wrong, it would not follow that it was an error apparent on the face of the record, for there is a distinction which is real, though it might not always be capable of exposition, between a mere erroneous decision and a decision which could be characterized as vitiated by error apparent. A review is by no means an appeal in disguise, whereby an erroneous decision is reheard and corrected, but lies only for patent error. Emphasis was made by the Honorable Court. A review is by no means an appeal in disguise, whereby an erroneous decision is reheard and corrected, but lies only for patent error. Para 8. In Petition Devi versus Sumitri Devi, the court, after referring to Tungabhadra Industries Limited, Mira Banja versus Nimarala, Kumari Chowdhury, and Aribam Tuleshwar Sharma versus Aribam Pisak Sharma, held thus, quotes, Para 9, under Order 47 Rule 1 CPC, a judgment may be open to review inter alia if there is a mistake or an error apparent on the face of the record. An error which is not self-evident and has to be detected by a process of reasoning can hardly be said to be an error apparent on the face of the record, justifying the court to exercise its power of review under Order 47 Rule 1 CPC. In exercise of the jurisdiction under Order 47 Rule 1 CPC, it is not permissible for an erroneous decision to be reheard and corrected. A review petition, it must be remembered, has a limited purpose and cannot be allowed to be an appeal in disguise. The Para 9. The aforesaid authorities clearly spell out the nature, scope, and ambit of power to be exercised. The error has to be self-evident and is not to be found out by process of reasoning. We have adverted to the aforesaid aspects only to highlight the nature of review proceedings. So here, by this judgment, the Apex Court had in very clear terms stated the ambit and power of the review courts and what are the scope and ambit of power to be exercised in connection with such review petitions. And Your Lordship, there is another judgment. Uh, 2015 to SCC, page 390. Para 20 and 21. Para 20 and 21, 402.
Yes.
May I read the Lordship?
Yes.
Para 20. In the review petition, in our view, the High Court ignored the sequence of events and the full participation of sons, daughters, and grandchildren, including the first respondent, before the competent authority. Court of Review has only a limited jurisdiction circumscribed by the definitive limits fixed by the language used in Order 47, Rule 1 CPC. It may allow a review on three specific grounds, namely, 1. Discovery of new and important matter of evidence, which after exercise of due diligence was not within the applicant's knowledge, or could not be produced by him at the time when decree was passed or order was made. 2. Mistake or error apparent on the face of the record, or 3. For any other sufficient reason. Application for review on the ground of discovery of new material should be considered with great caution and should not be granted very lightly. Para 21. Factum of death of Athili Narayasiyama on 15/9/1977 and plea as to non-impleading of legal representatives in the proceedings before the competent authority was raised at all stages before the appellate authority, as well as before the single judge and also in the writ appeal. Considering the participation of sons, daughters, and grandchildren of Athili Narasayama before the competent authority, the appellate authority as well as the learned single judge held that the legal representatives of Athili Narasima had sufficient opportunity of putting forth their objections on behalf of Athili Narasima, and the order passed by the competent authority does not suffer from any illegality. In writ appeal number so and so, the division bench also considered this aspect and found that all the legal representatives were already on record and participated in the proceedings and cannot complain of non-impleading of legal representatives. In the review petition, while setting aside its own order and then orders of the authorities under the ULCR Act, the High Court observed that there was no proper representation of the estate of the deceased, Athili Narasimha, by proper legal representatives, and any proceedings taken against a dead person are totally void ab initio, and the order dated 5/1/1982 is void and illegal. While so saying, the High Court has completely ignored the participation of sons, daughters, and grandchildren of Athili Narasimha in the proceedings before the competent authority. The said objection was considered and negative by all the forums. Insofar as the applicability of ULCR Repeal Act is concerned, in the impugned order, only passing observations have been made that all the proceedings have no effect in view of the Repealing Act. In our view, the impugned order passed by the High Court in the review petition is erroneous and not sustainable. Your Lordship, here in this case, the legal representatives of the deceased, Athili Narasimha, were not impleaded, it seems. So the stand taken by them is that the sufficient opportunity was not given to them. But that was accepted by the High Court. And in doing so, while so saying, it says, the High Court has completely ignored the participation of sons, daughters, and grandchildren of Athili Narasimha in the proceedings before the competent authority, and the said objection was considered a negative by all the forums. So similar, I'm just trying to draw a similar line here, Lordship. All the departments have participated in the spot verification, which was jointly conducted as directed by the Honorable High Court in the earlier writ petition. And while making such spot verification, it was the finding of the team that those departments were also in occupation of the lands of the plaintiffs, the appellants, for the period indicated against their respective departments. And they were occupying such lands in succession to the paramilitary forces who had vacated the lands earlier. And now, in the review petition, they have made a plea that they were already issued land lease certificate by the department much prior to so-and-so date, which they had not brought out during the course of joint spot verification. How can the Honorable Court rely upon such statements? When the spot verification was conducted, they ought to have said all those things, which they did not say. They were simply sitting and observing and saying that, yes, we are in occupation of these lands, which are belonging to the plaintiffs. There are about 5 departments, and they all have put their signatures as a token of acceptance of the finding of the verification team. And just because they said that defendant number 2, who is the respondent number 1 here now, have take a plea that we are not given a copy of the plaint. We are not given sufficient opportunity. And just because of that, the order of the trial court was reversed so easily, acting as if it were an appellate court, making a different finding other than the finding that was recorded by the trial court. And, my Lordship, the review being a specific provision and the ambit and the scope of review being very restricted and very limited. The order that was passed as per the application for review and as submitted by the learned counsel on behalf of the review petitioner, having been simply accepted, reversing the order passed by the learned trial court, cannot be sustained in law, inasmuch as it is against the principle and the provision of Order 47, Rule 1, CPC. And, my Lordship, in respect of that, the Supreme Court, in a category of cases, had laid down the provisions under which review power can be exercised. And I have just pointed out only 2 instances. The Lordship knows that the review power is very limited. They could have filed an appeal, no doubt. Even if it is an ex parte decision, they could have filed an appeal because if they are aggrieved. But till date, even those pro forma respondents, the other departments other than the defendant number 2, they did not file even an appeal till date, indicating thereby that they have accepted the verdict of the learned trial court, the decree passed by the learned trial court. And they are ready to pay compensation because they have occupied the lands of the plaintiffs. So in the view of the matter, Lordship, my humble submission is that the review order, the impugned review order passed by the learned review court cannot be sustained in law and it needs to be interfered with. With that, I conclude.
Yes, Ms. Linda.
My Lord, it's going to be lunchtime. I don't know whether we should continue or...
You can come post-lunch.
Lordship, even if more time is afforded to the learned counsel, government counsel, if the matter can be taken up next week, Monday, as part of it, I have no objection.
Yes,
Why not today?
Lordship, I have to attend the wedding ceremony of one of our juniors in the chamber.
You have completed your submission.
Yes, I
She'll
have
make a
completed.
submission, then we'll see.
It's up to her.
My Lord, we can take it up next Monday.
Monday, Tuesdays, I have difficulties. Is the problem.
Okay, in that case, can wait.
You know. Wait, Monday.
Why not? 춘좀 대미.
Your junior can be here, she can make a submission.
No problem.
How long will you take, Ms. Linda?
My Lord, there's nothing much to say, but
Or in other words, if the Lordship permits, if there's nothing much to say, 15 minutes instead of the whole
take
afternoon.
it up on Wednesday or Thursday also, if possible.
It's better to complete today itself. Mr. Ramzan has completed his part. You have any problems in the afternoon? Ms. Linda?
Okay, my Lord, we can do it today itself.
You come back at 2. Mr. Ramzan, you let your junior stay, or if you have difficulty. If you want to make a reply, it's a different thing.
All right. My junior will stay. Sẽ quy nghĩa chưa?
Yes.
Yeah, please, Your Lordship. Lordship, I'd like to point out first that the order passed by the senior civil judge at page 122, that is in the review petition, this has been rightly passed by the learned senior civil judge. The point which I'd like to take is that, my lord, firstly, an application for review of a judgment. Any person considering himself aggrieved by any decree or order from which an appeal is allowed, but from which no appeal has been preferred, by a decree or order from which no appeal is allowed, or by a decision on a reference from a court of small causes, and who from the discovery of new and important matter or evidence, which after the exercise of due diligence was not within his knowledge or could not be produced by him at the time when the decree was passed or order made, or on account of some mistake or error apparent on the face of the record. Firstly, my lord, in this regard, account of some mistake or error apparent on the face of record, I'd like to point out that the trial court which has passed the order, ex parte order, has made some error. Page 95 is the order, my lord. At page 95, the last para, here the learned trial court has held that the plain copy was duly served to the defendants on 7/3/2018, which was reflected in the order, and the case report also clearly shows that the learned AGA had sent for instruction on 11/4/2018 to the defendants, my lord. In this regard, my lord, as we have already pointed out in our review petition, the department will never furnish a copy. It was wrongly given a copy to the DC, Deputy Commissioner only, and the department were never made aware of this case. The letter which has been sent can be seen at page 111, 111. Yes, madam. This is addressed to the District Collector, Deputy Commissioner. Sir, please find and close herewith a copy of petition in connection with the above subject. The case was taken up before the Court of Senior Civil Judge, Kolasip District, Kolasip, at the stage of submission of written statement, and wherein the Honorable Senior Civil Judge Court is pleased to issue notice returnable within 1 month. I therefore request you to submit parawise comments before the returnable date. This is, my lord, addressed only to the Deputy Commissioner, whereas there are other important respondents, the other respondents who are to pay, my lord. In fact, DC is not a very important respondent in this case, and the Revenue Department as well as the other paying department, they are not made aware that a case was registered against them. So this is my first point, my lord. And for the other point, as per the as per order 47 rule 1, my lord, or for any other sufficient reason, we will come under this, my lord, for any other sufficient reason. The reason being that, my lord, there is a concealment of facts in the case, and the learned trial court has simply passed an ex parte order ordering us to pay for rental compensation.
You were stressing on account of some mistake or error apparent on the face of the
Yes, my
record.
lord. With that, my lord, the learned trial court has held that the department were furnished a copy, and therefore a decree was, ex parte decree was passed against us. However, my lord, there is no proof to show that we have received a copy. The letter which I've shown is addressed only to the Deputy Commissioner, which is not even the paying authority.
Then what about the review petitioner being just the secretary, revenue department?
Yes, my lord. With regard to that, my lord, the Revenue Secretary has acted on behalf of all the departments. Any aggrieved party can file a review petition. And here the Revenue Department has taken initiative on behalf of all the departments and have filed a review. In fact, all the other departments are aggrieved. But to make the matters speed up, my lord, one department has taken the initiative.
Yes. So,
And the other reason is, my lord, we can come under any other sufficient reasons for review. Because, like we have stated, there was concealment of facts. The passes itself, my lord, we are
what do you say,
doubting the-
concealment of facts?
Concealment of facts is that, my lord, the passes were already cancelled. The BC passes were already cancelled. And in
Okay.
place of that, we already have issued a departmental land lease.
Okay, but where is that in your review petition?
Review petition is at 106. At page 107, my lord, the grounds which we have taken.
Any document to show that the pass were been cancelled?
Annexure is given here, my lord, annexure 3 and 4. The land lease is annexed here, my lord. Annexure 3 is how PHE department was allotted a land bill for clear.
Does it mention anything about cancellation of the VC pass?
No, my lord. Let me read out the whole thing, my lord. Yeah, it's written out, and nobody constructed a house even during this time, and the land was vacant. In the fourth para. Let me read out, my lord, the whole part. How PHE department was allotted a land at Bilkotlir. To ensure that the villagers of Bilkotlir receive a clean water supply, the government took an initiative through PHE department, while our former local leaders helped identify the location for PHE water reservoir tank 3 and the quarters. With PHE department settling in the area, the residents of our village began to receive clean water supply. PHE department is located at Munsamplang area, and the area is 3 bighas wide. Let me mention a brief history of Munsamplang area before it was allotted to PHE department. Early residents of Bilkotlir settled in Munsamplang area since 1929. In the year 1958, the present police outpost and PHE main reservoir tank was excavated for a playground using bulldozer. The game president during this time was Mr. Rohing Thanga. The last tournament played in this field was on 16/3/1964, and it was on account of Mr. Dara's memorial shield. This field is a major playground during those days. With the outbreak of insurgency in the year 1966, Munsamplang was occupied by the Indian Army, and they evicted all nearby dwellers of the area. After insurgency, the army left Mun Samplang area and the area remains a vacant land for a certain period of time. The community leaders announced that if houses are not constructed on vacant land inside the village before March 1983, the respective parcels of such lands will be cancelled. That is VC sitting number 16 of 1983. Nobody constructed a house even during this time and the land was vacant. With the land being vacant and also to meet the need of the community, the vacant land of Mun Samplang was allotted for a police outpost on 22/4/1991. As per VC sitting number 6 of 92, dated 22/4/1991, our community leaders sliced out portions of police outpost and allotted the land to PHE department for construction of PHE reservoir tank 3 and quarters. In the register that records VC pass allotment, there is no detail recording VC pass allotment in the year 1962. However, the handwriting and signature of the then VCP, Mr. Rohing Thanga, can still be seen. We are a witness to the fact that the former community leaders allotted the reservoir tank 3 and quarters to PHE department inside Bilkotlir area as mentioned above. So this is how, my lord, the PHE department were granted the land. And at page 117, this is the departmental land lease that has been allotted. This is
So this is the basis of your submission that the material facts were concealed.
yes, my lord. This has to be brought out, otherwise, my lord, great injustice can be done to the department as well as to the state itself, my lord, because
What do you say about that assessment made by the collector at that relevant time and forwarded by the...
that was way back, my lord. The assessment was made in 2015. That is after the joint verification. Thereafter, my lord, all these other facts that cropped up, my lord, that is why they were not paid any compensation. And even in the spot verification, your lordship will see that not all the departments were included in the spot verification.
Where is the spot verification?
The order is
60?
given in WPC, page 43.
What about page 60?
60.
Yes, 60. Is this not the one?
Yes.
So it seems there all the departments were there.
Scholarship.
Yes, what else?
But no prejudice will be caused if the review order which was allowed by the learned lower court is, my lord, upheld, because it will be sent, my lord, will go from the stage of evidence, and the facts will be clear, my lord. Otherwise, my lord, it can cause grave injustice to the department if the review order is not allowed, my lord, at this stage.
Okay. That's it?
Yes, my lord, that's it.
Yes, Mr. Ramzan, any reply?
Your Lordship, so far as the communication letter at page 111, which has been relied upon by the,
Yes.
here this is a letter addressed to the district collector, deputy commissioner, in which only one copy of the petition was sent to the district collector. It does not mean that all the copies of the, supposed to be served by the deputy commissioner to all other defendants were sent to the deputy commissioner, and the deputy commissioner did not take action in sending out. Here, it is apparent that please find enclosed herewith a copy of petition in connection with the above subject. The case was taken up before the Court of Senior Civil Judge, Colosseum. The Colosseum at the stage of submission of written statement, and wherein Honorable Senior Civil Judge is pleased to issue notice, returnable within 1 month. I therefore request you to submit Parway's comments before the returnable date. There is no indication that the Lanet AGA did not send any other letter to the other defendants. This letter has been sent, of course, addressed to the district collector, who was the defendant number 7 at that point of time. All the others were also likewise sent, and they did not take any step for countering or to take any action for submission of WS. So just because this letter was the loan letter submitted by the state government or the respondent, defendant number 2, for countering or for making a submission that no other letters were sent. I think this is only a very strong presumption which cannot be accepted. And the reviewing department had taken the initiative on behalf of all the other departments. That was the plea, the submission of the Lanet additional AG. But this does not appear to be so, because if the other parties, the other defendants were aggrieved, they would have joined. This is the procedure. And Lordship, when they did not join in the proceeding, and when they did not file even an appeal against the said order, it cannot be presumed that they had the same grievance as that of the review petitioner. And Lordship, yes, Lordship has rightly pointed out that as per the assessment joint verification report, the parties, all the parties were represented, and the manner in which the lands of the different petitioners and the different plaintiffs have been occupied was clearly indicated. And though they said that there's a concealment, but the question of concealment did not arise when we had approached this honorable court by way of a writ petition. The writ petition was disposed of with the proper direction, and even at that point of time, there was a possibility, there was every chance on the part of the defendants, who are also the occupants of the lands of the plaintiffs. So the respondent number two, the respondent number one, defendant number two, is trying to make out a case so that the payment of the rental compensation and other compensation as assessed by the competent authority on the direction of this honorable court was averted. But the thing is, Your Lordship, they are not making any such averment as to the payment to be made by the paramilitary force. When it was fully accepted that even paramilitary force, they were occupying the land till 1989, and even thereafter, when they had vacated the land, the departments continued to take over without any authority, and the question of concealment of material facts by the landowners, by the appellants, did not arise at all. And Lordship, there is another thing which I'd like to point out, that during the course of trial, the evidence was tendered at page 79 to 91 by Sri B. Lalbiaksanga, 79 to 91, and he was cross-examined. The cross-examination part is at 88, page 88. All the documents were exhibited. 89, 90. From 91, there's a cross-examination. Let me read. Para 4.
Mr. Ramzao, it may not be required because we are not examining the merit of this case
Right.
as it is, isn't it? It's basically review was passed in favor of the state. So whether that review was correctly entertained and allowed or not, that is the only thing which is to be examined.
But what they
What
have,
you want to say is that you
they have
examine.
fully accepted. They have fully accepted. It is in para 4. It is a fact that the armed forces occupied the disputed land till 1989. It is a fact that I'm born. It is a fact that as soon as the military force left, and even before that, our land was occupied by the state government for construction of offices and quarters. When the suggestion is given, and if the answer is given as it is a fact that, the suggestion could not but be, I say that it is a fact that so and so happened that way. So the answer is in the affirmative, saying that it is, yes, it is a fact. That, so even at the time of cross-examination, it was fully admitted by them that they were in occupation of the land of the plaintiffs. So They had every opportunity of producing or showing whatever document they have, and they did not bring it to light if they have a need. But what they have stated now is too late in the day, and after everything is decided, by way of review, my humble submission is that those documents cannot be part of the documents at this stage, cannot be admitted at this belated stage. So the review has no merit and it needs to be interfered with. This is my humble submission. That's it.
I'll consider and pass necessary orders. Okay, will not be CAB.
Lordship, one small submission is, I don't know whether it will be relevant or not. After the review was allowed, my lord, we have filed FIR to the officer in charge of Bilkot police station regarding the forgery, my lord, with regard to the signature of the VC passes. I don't know whether this, what is the stage of the investigation or the police report yet, but we have filed a FIR.
There is some development, isn't it?
Yes.
But it's not a part of this particular record.
Yes.
Okay. Heard Mr. Seal Ramzawa, learned senior counsel, assisted by Mr. Sorry? Stephen Lalbotsaya for the appellant. For all the respondents. Orders to be passed separately. Send me these books.